Please be seated. So the first case on our docket this morning is captioned Phillips v. People. We've set this for an hour argument. Looks like both counsel are situated. Petitioner, why don't you begin your argument?
Good morning, and may it please the court. My name is Shan Jeffrey. I'm here on behalf of Leo Phillips, the petitioner. The issues announced for today's argument are: 1, whether the Court of Appeals reversibly erred when it held that Mr. Phillips waived his right to challenge the admission of the gun that was seized from his vehicle on voluntariness grounds, and 2, whether the Court of Appeals reversibly erred when it held that Mr. Phillips waived his right to challenge the admission of his police station statements on the grounds that they were tainted by his earlier unconstitutional interrogation. And because this argument is fact-intensive, I'm just going to briefly outline what happened, just to refresh. So in this case, Mr. Phillips was driving with a suspended license. He had passengers in his car. An officer stopped him, Detective Fish, conducted a pat-down, and then conducted an unmirandized custodial interrogation of Mr. Phillips in the back of his police vehicle. During that interrogation, Mr. Phillips told the officer about his prior felony conviction, which was an element of the PALPO charge, and he allegedly consented to a search of his vehicle after allegedly being advised of his right to refuse. There was no search warrant. Another officer conducted the search of the vehicle and found the handgun under the driver's seat. And then Mr. Phillips was transported to the police station where he was subjected to a second custodial interrogation. The officer at the suppression hearing testified that that interrogation was preceded by a Miranda advisement and a waiver, although there was no physical evidence of a waiver by Mr. Phillips. At trial...
Ms. Jeffrey, while you're going through the facts, could you talk a little bit about the second interrogation? I think there's at least an allegation that it was broader than the first, and I expect you to be arguing Cybert, so I'd be interested to tell me about that second interrogation.
Right. I do believe it was broader than the first, but even the prosecutor at trial argued that the interrogations were similar in sum and substance. I think that's a concession that we can count on since it came directly from the prosecution at trial. And it's normal that it would be a little bit broader since it was the same officer conducting both interrogations, and he was already informed by what had been said during the unmirandized interrogation in the vehicle. At trial, the defense filed a motion to suppress the police car statement and the station house statement and the gun taken from the car. After the suppression hearing, the trial court ruled that the police car statement would be suppressed because Mr. Phillips had been subjected to custodial interrogation without the benefit of Miranda warnings, but that the station house statements were admissible based on the officer's testimony that the Miranda advisement had been given and that those rights were waived. And also that the gun was admissible because it was seized during a valid consent search. On appeal, the Court of Appeals refused to consider whether the defendant's police station statements were the inadmissible fruit of the earlier unconstitutionally obtained statements in the police car, because Mr. Phillips did not articulate this precise argument at the suppression hearing. The Court of Appeals, in effect, found that the failure to articulate this precise argument at the suppression hearing waived appellate review of whether the defendant was entitled to relief on the merits of this argument, even though the defendant argued in the motion to suppress that the prosecution bore the burden of establishing that a derivative statement was not tainted and the fruit of a prior incriminating response resulting from illegal custodial interrogation. The Court of Appeals also refused to consider whether the defendant's alleged consent to search the vehicle was tainted by the custodial interrogation with no Miranda advisement. In other words, whether it was involuntary, invalid consent. Again, the Court of Appeals characterized this as a new argument that the defendant never presented to the trial court and declined to address it, even though the defendant had moved to suppress the gun and argued at the suppression hearing that the prosecution did not prove voluntary consent. The flaw in the Court of Appeals analysis is that it singles out the defendant to bear the entire burden to perfectly articulate the relevant legal analysis based on the historical facts as developed at the suppression hearing. This burden of articulating and then applying the relevant legal analysis cannot be placed entirely on the defendant's shoulders.
Why not? As the movement in the suppression hearing.
Yes, it's the movement, but it ignores the independent duties of the prosecutor and the trial court, and then the appellate courts as well. Because we're in the Fourth Amendment context, and because there has been a warrantless search, and there has been an interrogation without the benefit of the Miranda advisements, it then becomes the prosecutor's burden to prove that the search was conducted pursuant to a valid voluntary consent. That's People v. Herrera and Florida v. Royer in the United States Supreme Court. And that the defendant's statements and the Miranda waiver were voluntary. And that's Eflin v. People. That burden of the prosecutor is independent of the movement's burden to articulate all of the relevant law and fact in the motion to suppress, because once the general claims are made about consent needing to be voluntary and valid, and a search needing to be voluntary, then the burden shifts to the prosecution.
I mean, that's fair, and obviously the burden does ultimately rest with the prosecution, but it seems that in terms of laying out the parameters of what exactly the prosecution is going to have to defend against at the suppression hearing, that burden lies with the defendant to sort of outline the game, if you will, whatever's going to be playing out.
Well, I think here's where we can see a distinction between general constitutional claims under things like voluntariness of a search or voluntariness of a statement and precise legal arguments in support of those claims. And yes, of course, it would be nice if even prior to the suppression hearing, we had enough facts developed in the record or enough legal research done by the parties to precisely articulate every nuanced argument underneath those general constitutional claims, but it's just not realistic to expect perfect litigation at this stage of trial, especially since during the suppression hearing, facts are developed that lead one further down a road of legal analysis, and it's not always
Counsel,
foreseeable.
isn't part of the point, I agree that the point of a suppression hearing is to develop facts that will allow the trial court to make a determination, but those facts are developed based on the arguments that are made, right? If there's no argument made, for example, that there was this two-step process that the first interrogation and the second interrogation, then then no facts will be developed about whether that's the case, about whether the officer was operating intentionally to create a two-step process. If there's no argument about whether the voluntariness, if the focus of the argument at the suppression hearing is on whether the consent was voluntarily given in the sense of did the conversation between the officer and Mr. Phillips have a coercive element, then there's not going to be a focus on the question of whether any consent given in an un-Mirandized interrogation is necessarily involuntary. So the facts weren't developed because the arguments weren't made.
Well, it is certainly preferable to have the full roadmap in front of everyone prior to the suppression hearing, but it just doesn't always go that way because there is always the duty of the trial court to consider the totality of the circumstances when determining the overall voluntariness of a consent to search or a defendant's second statement after a Miranda warning. That's Jennings, and in this case, it's also the Breidenbach case. And it's nice if those tests can be articulated in advance, but sometimes as the facts are being developed, such as when the court did find that the first interrogation in the car should have been subject to Miranda warnings, then it follows that the applicable law, those legally relevant facts that the court found, those findings of historical fact, lead to a particular legal analysis that must be applied. And there is an independent duty of the trial court to correctly apply the law to the findings of historical fact, even if the court's findings of historical fact invoke a new legal analysis that had not yet been articulated at the hearing.
Ms. Jeffrey, I'm wondering whether we're conflating two different issues here.
Yes.
I mean, it seems to me the first question and the one we're going to cert on is whether there's a waiver. So was there an intentional relinquishment of a known right? In here, I mean, I suppose, you could feasibly argue, I guess, if even assuming the motion was boilerplate, which is how Judge Daly saw it, you can argue whether that's a waiver or not. At least said the words, there's an issue. That's separate from whether Mr. Phillips, is able to establish, assuming we're going to review for forfeiture, the grounds. And that seems to me the problem when there's no evidence as opposed to a waiver. Am I missing the boat? I mean, aren't there? Isn't it two issues?
It is two issues. The state has argued in their briefing that there was an intentional relinquishment of a known right, which is the definition of waiver under Olano. Here, though, there is no evidence, either express or implied, that if these arguments that were not made in the trial court were forfeited, that they were in fact intentionally waived, and that in fact trial counsel had considered the Siebert case or the Elstad case or the Breidenbach case or the totality of the circumstances under Jennings, and then purposely decided not to litigate that at the suppression hearing. There is no evidence that that was considered, known, and then abandoned. So we can't call it waiver. At best, or not at best, but at most, under the preservation, we can call it unpreserved and forfeited, but not waived. However, it's my argument that it was preserved, even though it's not perfectly preserved, because once you have made those broader constitutional claims of the voluntariness of the consent search or the voluntariness of the statement or the Miranda waiver the second time, that necessarily invokes whatever applicable law must be applied to the findings of historical fact by the trial court.
Well, let's assume you're right, that it's preserved for purposes of the question. Didn't the court here make findings that the second statements were voluntary and that the search that found the gun was consensual? And aren't we stuck with that?
Well, the court reached those conclusions, but without undertaking the proper legal analysis to get there. The court did not have the right cases in mind, was not familiar with the governing law, and in the Fourth Amendment context, it's very well settled that those are mixed questions of law and fact, and that while the findings of historical fact are due deference by the appellate courts, the application of the relevant law, first, what is the controlling law? And then the application of that controlling law to those findings of historical fact, that is de novo review by appellate courts, and certainly subject to correction on appeal.
So what evidence in the record supports a finding of a deliberate two-step interrogation here?
Under Siebert. let me get to the Siebert test, and I'll be able to answer that more articulately. So Siebert says that when there is a unmirandized interrogation followed by a Mirandized interrogation, that the court should consider the following factors. 1, the completeness and detail of the question and answer the first time. 2, overlapping content of interrogations. 3, the timing and setting of interrogations. 4, the continuity of police personnel. And 5, the degree to which questions the second interrogation were a continuation of the first. Here we do have a fully developed historical record that from which the trial court could have considered these factors, but just didn't. The completeness and detail of the question and answer was set forth by Detective Fish, and discussed. The overlapping content of the interrogations was also discussed on the record. They did overlap entirely. The timing and setting of the interrogations, one followed in close sequence to the other. There was no intervening factor. Mr. Phillips was transported directly from the patrol car to the station house, where the interrogation was simply repeated and then added to, but also repeated. The continuity of the personnel, the same Detective Fish interrogated Mr. Phillips both times, and so he was fully aware of everything elicited during the initial unmirandized interrogation. And the degree to which questions were a continuation of the first, well, it was a perfect continuation of the first, repeated and continued, since it was the same interrogating officer.
And I appreciate you going through that. So my concern, I suppose, is everything you said could be, I think could be said in almost any situation where there's an unmirandized interrogation and then a Mirandized one. The facts in Seibert where the police officers were specifically trained to do this, to do a two-step interrogation, and I don't think there's anything like that. So help me with that. I'm just a little concerned, just saying there's some evidence on each of those factors. I understand the argument, but it seems to me like if we say this is enough, then pretty much any time there are this kind of two-step, it's going to be enough. So tell me what gets you to the deliberate part of it.
The officer, Detective Fish, was very aggressive with his questioning in the initial interrogation. Certainly he was not free to leave. He was confined to the back of the patrol car while his passengers were waiting for him in the vehicle. There was a degree of coercion for certain because he wasn't given the benefit of the Miranda warning. He was not given the opportunity to consult with counsel. Under those circumstances, it's a lot easier to overcome someone's will to remain silent because they're not being advised of their rights. And then that coercion extends to the second interrogation because you've already said everything and you've already given up all that information in the first go-round. Now, was he questioned on whether this was deliberate? I don't think most officers would admit to that, even if it were. So I'm not sure that's a realistic standard to be asking for.
Those were the facts in Seibert, and they admitted it.
Right.
And they were trained.
I think that's fairly rare.
Fair enough.
I've not seen it, but I guess it could happen that they would admit that. However, if you do believe that that type of question is necessary to the analysis and cannot be inferred from the record, then I think the remedy is to remand back to the district court for a supplemental suppression hearing so that those historical facts can be further developed and then the correct analysis can be dealt with at the trial court level first.
Could I take you back to the preservation issue?
Yes.
So your position, at least in the brief, and I sort of hear you saying it today, is that by simply filing the motions that sort of generally put the issues on the table, that was enough to preserve both issues that you're talking about today, right?
I think it's enough to preserve it in as far as it's not waived. Yes, once you get to the suppression hearing, the facts are developed further. The prosecution's burden to prove a justification for a warrantless search, or that an unmerized interrogation, or one that follows a second interrogation that follows a first unmirandized interrogation is not involuntary. I mean, that burden kicks in at the suppression hearing, and so does the trial court's burden to correctly apply whatever the law is to the relevant facts that are being developed there.
Right. And I guess that's where I want to press you a little bit, because as you well know, typically, probably with the assistance of the appellate unit at the Public Defender's Office, the trial deputies are filing motions that contain references to almost every conceivable thing that might come up at a suppression hearing in order to help to preserve issues for appellate review. And so given that that's the way that things typically unfold, it's sort of in line with what Justice Marquez asked about at the outset. Why shouldn't there be more of a burden on the defense attorney to tee things up for the trial judge who's otherwise just looking at a sea of very general allegations about suppression issues?
Well,
And why doesn't that constitute, to use your language, considering and abandoning issues that aren't set forth in those more sort of boilerplate motions? You'll forgive my use of the word boilerplate.
okay. Well, first, I do want to reiterate that I did argue for plain error analysis if you do find that these were not sufficiently preserved for harmless error analysis. But that aside, first I have to challenge your assumption that the trial deputies are consulting with the appellate deputies of the Public Defender's Office before they file these suppression motions. This is not an appellate motion.
No, I understand.
Okay.
But my inference is that there are templates that are out there that are probably crafted with the assistance of people who are more familiar with how to preserve issues. Regardless of how it happens, I know in countless cases I've seen these motions that talk about a wide variety of things that might come up on appellate review. And so how is that sufficient to put the trial judge on notice of what actually needs to be litigated at a suppression hearing? And historically, it does seem that we rely on defense counsel to say, here's what we're here for today.
Yes, it's always helpful when a comprehensive, well-researched motion is filed. It's not always the case that that happens. There are not boilerplate templates that every trial deputy uses to file these. In fact, in our conferences, we're always training on you need to be specific with your arguments and not just rely on boilerplate language, but that does not always happen. Our trial deputies have 300 plus cases on their caseload. Sometimes it's not, we cannot expect perfect litigation, but here's where I think that really comes into play. We cannot call it waiver, because if someone has messed up and they have not researched properly, or they have not issue spotted properly, and they don't give the court the best law for it to reach the best conclusion, that does not mean it was ever considered and abandoned by these trial deputies that have a zillion clients at one time and are doing many trials at one time. We cannot expect perfection, and we especially cannot expect it only from defense counsel. I'd like to reserve the remaining time if I could.
I challenge you a little bit on that at the end. I know you want to preserve your time. You're saying defense counsel can't be perfect, but the trial court's supposed to fill that gap?
I think between the
Supposed
three
to
parties.
they were supposed to jump in and issue spot for the defense counsel.
Well, between the three parties, Your Honor, I think it's kind of a system of checks and balances, frankly. I think it's great when the issues can be perfectly developed in the suppression hearing itself and in the suppression motion itself, but when historical facts are found by the trial court in the suppression hearing that lead down a different path than has already been briefed before the court, then I do think that both the prosecution's burden of proof kicks in and the trial court's independent duty to get the law right kicks in.
Let me push back on you a little bit on that. If it's so obvious to the trial court and to the prosecutor, why wasn't it obvious to defense counsel? I mean, why is this not just an ineffective assistance? Because then we can ask counsel, did you consider these things? Did you abandon them? What was your strategy? What did you do? I mean...
But Your Honor, how was it so obvious to the prosecution and the trial court if no one cited to Breidenbach or Elstad or Siebert I'm not sure it was.
You seem to
there-
be arguing that it should have been, and therefore
that
it's
was
It
my
should have
point,
been.
yeah.
Yes, it should have been, but I'm not saying that it was.
okay.
And isn't that what plain error is about?
Exactly, Your Honor.
I mean, the definition is that it was so obvious, error, the trial court should have done something and it affected the result.
That's right.
And in most cases, the defendant is going to lose that argument.
That's right, in most cases. But it's the catch-all because we're talking about constitutional rights. Thank you. I'd like to reserve.
I'm going to ask you this on rebuttal if I don't ask you this now. So I'm just going to have you say something now. So opposing counsel argues that suppression is different and that that a suppression hearing should not be held to there shouldn't be plain error review of arguments not raised at a suppression hearing, even though there might be of arguments not raised at trial. I assume you disagree with that.
I do disagree with that.
Why? Why isn't suppression different?
Well, we're still talking about constitutional rights. And in fact, in the context of a suppression hearing, the law is even more defined than when you're just out making evidentiary rulings at trial, meaning that we can expect the court to take into consideration all the legal relevance of all of its findings of historical fact and to apply the law correctly. And if that's not done, then plain error review is where we make things right. And it shouldn't just be a 35C claim because that puts all the burden on the pro se defendant to litigate this in a pro se 35C motion after the fact when everyone with legal training has failed at the different levels to vindicate those rights. Thank you.
Good morning. May it please the court. My name is Majid Yazdi, registration 36043, representing the people in this case. This case presents two procedural issues and two substantive issues. The procedural issues, as was discussed, are preservation and waiver. The substantive issues are whether there was a Miranda violation, both at the roadside questioning and at the police station questioning. And the second question, substantive question, is whether the consent to search was valid. Obviously, the starting point is the preservation question, and the issue is whether the defendant preserved the substantive claims. The Court of Appeals, which included, by the way, Judge Berger, who dissented in Cardman, the case that this court will hear right after this case, unanimously concluded that the issues presented by defendant were not preserved and were waived. This court in Jensen stated that motions to suppress should state with reasonable specificity the legal grounds upon which the motions are based, so as to put the prosecution on notice of the contentions it must be prepared to meet at a suppression hearing and to inform the court of the issues to be decided. And a line of Court of Appeals cases followed that holding, and so it is a law that has been settled. There's no question about that. In McIntyre, this court again said that to make meaningful appellate review possible, trial courts must make sufficiently clear and detailed findings of fact and conclusions of law on the record before ruling on the voluntariness of a confession. So obviously, when the issues are not sufficiently presented and argued, the court would not be able to do its duty under this law.
So
Now-
let me just jump in. So the question obviously becomes what's sufficient. We have a lot more cases from the Court of Appeals talking about how that line should be drawn than from this court. But is it your contention that there needed to be both a detailed written motion and a detailed oral statement of the issues that were teed up for the court. You tell me what you think is sufficient to actually succeed in preserving these issues. What should have occurred?
I think it's reasonable to look at the motion, at the arguments and evidence presented at the suppression hearing, and looking at the court's ruling if those issues have been sufficiently addressed or not, because if they are not, obviously defendant can raise that question with the court and say that I raised this issue and you did not rule on that, so seek ruling on those issues. And here we look at...
So let me make sure I'm understanding. You seem to be now attaching a third thing that the defense counsel has to do. You got to file it in the written motion, you've got to tee it up orally during the course of the motions hearing, and then when the judge fails to address it during his or her findings and conclusions, you have to jump in and say you failed to address it. Otherwise, if you don't do those three things, it's unpreserved.
I believe that's what this court said in Inman.
Okay.
So let me ask you, Mr. Yazdin, good morning to you.
Good morning.
Help me understand, you make a compelling argument here for lack of preservation. Help me understand why this is waived as opposed to forfeited. I mean, the motion did say the prosecution has the burden of establishing a derivative statement was not tainted in the fruit of a prior incriminating response. So the defendant put on the table, even assuming your word, assume it's boilerplate, on the table is a kind of fruit of the poisonous tree position. Why is that a waiver? I could hear better a forfeiture, but I'm not understanding why it's a waiver. How is that an intentional relinquishment of a known right when you put the argument on the table in your motion?
I think the answer to that partly is dependent on the preservation issue as well. Because when we read the motion, when we review the argument, it shows that it was a conscious decision by counsel to focus on what he believed to be the strongest argument and intentionally not considered the other arguments.
It's a fair point. And just like you and Ms. Jeffrey are doing today, you pick your best argument for your 15-minute or half-hour oral argument. That's what a good lawyer does. Why does that mean you're abandoning everything else? I mean, we often hear lawyers in this court say, I'd like to focus on issue 1 in my brief because of the time. That doesn't mean they abandon issues 2 and 3. They made a choice what to focus on in the argument. And again, I'm just stuck on why that's a waiver.
Why we can infer from that it was abandoned, is that the question?
Yeah, because
Well, because-
maybe why isn't it just a choice to use your limited time to focus on an argument you think was stronger? That's okay.
My response would be it's a reasonable inference from the behavior of counsel. We don't have counsel here to explain, if that would be under 35C, exactly what strategy he pursued and why he pursued that strategy. But we are not at the mercy of that evidence to make the inferences. We can make inferences, especially in a case like this. If Your Honor allows me, I can back the argument with specific facts of this case.
Sure, and I'd like to hear that. And let me just ask you also to address then, you talked about an inference of a waiver. We have constitutional rights here. We presume not a waiver. So why do you infer a waiver when the presumption is the opposite? So have at it, and I'd like to hear what you wanted to say about the facts.
I think these issues have been addressed by this court in Stackhouse, in Hinojos Mendoza, in Cropper. In all of those cases, we have, especially in Hinojos, Mendoza and Cropper, the court even considered the question of actual knowledge of defense counsel. And even though defense counsel had expressed, and the record supported, that did not know about the law, the court said that that is irrelevant. We still consider that to be a waiver. So those questions, as a legal matters, have been addressed. So we can consider basically waiver as a matter of law, even though it's not as a matter of fact. We have rules of procedure like the 41G, for example, regarding suppression that suggests that if defendant fails, counsel fails, then it is considered a waiver. Same thing with the issues in Stackhouse and in the other cases regarding the notice and demand statute for in-person testimony by lab technicians. So it is not unconstitutional to say that certain procedural defaults, whether we call them waiver or being considered procedural defaults, it is a waiver as a matter of law.
Can
That
I
would
ask-
be my argument.
Counsel, did I correctly characterize your argument as being that suppression hearings are different, that arguments not made at a suppression hearing are waived, as you just said, as a matter of law?
Yes, again, in Inman, the Supreme Court clearly states, and it's such a strong statement, I'd like to go back and read it, that appellate review of a suppression ruling is limited to the legal basis set forth in the district court's ruling and not necessarily the grounds alleged in motion. So it goes even further than what we are discussing here, that these, the preservation question, the issues raised were not raised on appeal, were not preserved. And going back to the preservation issue, I'd like to focus on the suppression motion. Of course, it was characterized as boilerplate, and it is boilerplate because there is no reference to the cases that are relied on appeal, for example, on Seibert, Elstat. There is no discussion of involuntariness of the consent. It's just unconstitutional challenges to the constitutionality of the statements and the use of totality of circumstances. I think that is obviously insufficient to put the prosecution on notice or the court on notice that these will be the issues. But more than that, we look at the suppression hearing. What was presented? The detective who testified was cross-examined, and the transcript for the cross-examination is 30 pages. 25 pages of that cross-examination focuses on the illegality, the alleged illegality of the stop and the lack of reasonable suspicion. Only 5 pages deal with the question of the statements that were made and whether Miranda violation occurred. We look at the defense witnesses presented. 3 witnesses were presented. All testimony was relevant to the question of whether the officer was credible in his description of how this stop was made or why this stop was made. Again, focus on the illegality of the stop. Defense counsel went out of his way, created an enactment of the stopping of the defendant, and played a video, presented a video as evidence of that, to show that the initial stop was illegal. The defendant did not testify, so we don't have any record of what kind of coercion was claimed, and that is claimed now on appeal was actually used against the defendant. Then we go to counsel's argument made to the court. 10 pages of the 15 pages that cover counsel's argument deal with the initial stop and whether it was legal or not. Only 5 pages are devoted to the other issues that are being raised on appeal. We read the court's ruling. What does the court rule on? What was presented to the court? And I'd like to read to this court how the court began ruling on the question of voluntariness, which is a major issue before this court. The court on page 82 of the transcript, which is the second day of suppression hearing, February 26, 2014, the court says, with regard to the search, I understand counsel's argument to be that even though Detective Fish testified that he received a waiver from Mr. Phillips, that there is no written form of the waiver, and then argues that inferentially, especially these credibility issues, should lead the court to conclude that that doesn't meet the standard of clear and convincing evidence. I'm not persuaded. That's the only issue that the court addressed regarding voluntariness. And now we expect the court to go out of its way just because the word totality of circumstances was used in the motion to read some other, to address some other bases that could be raised on appeal as making the confession or the consent search involuntary. I think that's too much to expect from a trial judge.
So why not, in a post-Reina Abarca, Rediger world, aren't we at least looking at plain error review? Don't those more recent cases sort of change the landscape, as Justice Gabriel's earlier question suggested?
I think plain review would be inappropriate here because of lack of factual developments made at trial. For example, when we talk about double jeopardy, whether it was preserved or not, and it can be still reviewed under plain error, which this court has decided. Yes, because it only involves legal issues. Here we have clearly a situation that cannot be addressed without the facts presented before the trial court and determined by the trial court. I have mentioned, and Justice Gabriel raised it this morning, that how do we know that there was a two-step questioning, interrogation strategy adopted by the detective in this case? We don't know. There were two questioning, but we don't know the extent of the second questioning at all, Justice Gabriel, I'm sorry. We don't know that because it was not developed. Defendant did not raise it. The questioning of Detective Fish in this case does not focus on that, and it is interesting. Before asking on direct examination what happened at the police station, the prosecution asks, is defense counsel questioning, challenging the statements made at the police station based on the fruit of the poisonous tree or some other argument? And the response is that I'm challenging all the statements, that's it. How would the prosecution know to inquire about the extent of the questioning that happened at the police station? We know from the examination that was done, not focusing on this, that Detective Fish said that after the gun was found, I told defendant we have to go to the police station and we discussed the gun issue and possession and issues related to that at the station. So we can infer from that record that actually what happened at the police station focused more on not what was done in the back of the patrol car, but actually focusing on what was discovered through the search.
Mr. Yazdi, good morning. I seem to remember the defense arguing in its brief that the record here is sufficient for plain error review, assuming that plain error review takes place. I don't remember you contesting that, and maybe I missed it, but what I remember in your brief is that you argued that to the extent that plain error review takes place, here are the reasons why you should prevail. So are you changing your position on that? I guess I'm a little confused based on what you just said.
I think I have made it clear that it is not preserved and it is waived, so obviously plain review would not be applicable if it is waived.
No, I'm not trying to say that you're being inconsistent in that regard. My understanding of your brief was that in the alternative, you argued that to the extent that plain error review applies, that there's no plain error here.
Yes, I have argued that, and I'm saying that.
Sounded like just now you were saying the
I think that it's not an appropriate resolution of the case to apply plain error, but even if you apply defendant's claims fail under plain error review, I'm not changing that.
Well, I guess I'm trying to figure out, is the record sufficient for us to conduct plain error review? Or
My argument, it's not, but I cannot, and I just anticipated this court disagreeing with me on that issue, and then I had to address whether, even if you were to apply plain error review, it would be, if you can do it or not. My argument is that the record does not support plain error. That's my argument.
All right, thank you.
So Let me just follow up on Justice Moore's question in a sense. Some cases, maybe some of the federal cases, as I recall, talk about a sort of middle ground where the record is sufficient to allow for plain error review or to allow for some form of review, then maybe it should occur. Are you suggesting that there should be that kind of ad hoc inquiry, or are you looking for more of a bright line rule?
I'm sorry,
Well, let me.
could you repeat that question?
Yeah, well, let me phrase it this way. You've told us today why you think that plain error review is really not possible on this record for a number of reasons. Suppose we looked at.
It's not appropriate. You can always try to do that, but it's not really, the record does not allow you to conduct a plain review of the issues.
Right.
That's
Right.
my
So
question,
because of
my
certain
argument.
deficiencies in the record that make it at
Exactly.
least less than ideal in terms of trying to resolve these issues that weren't raised. And so I guess my question for you is, suppose we have a record where it is sufficient, that it may be one that's different from the one that we have in front of us now, but that it fills in these gaps that you've identified. Would it be appropriate for us to say, well, on this record, we can do this, so we're going to conduct plain error review, whereas or are you saying that it should never even
think
get
that-
to that point?
I think, if I understand Your Honor's question, the assumption you're making is that when you say the record is sufficient, that implies that the factual issues that need to be decided were developed.
I see. So in an
Then it
intimate
would be,
sense,
then we don't have the question of preservation.
I understand. Okay, thank you.
You're welcome. Unless the court has any questions about the substantive issues, I think because the preservation and waiver are really the key issues to decide this case on, unless the court has a question, I just stand by the arguments.
Actually,
made.
I have a question. I'm wondering if you have a response to your opposing counsel's suggestion that in the event that the record before us is insufficient, we ought to remand for a supplemental suppression hearing.
I don't think that would be appropriate because, again, at the remand, the court doesn't have all the facts. We don't have the suppression hearing has already happened and the issues presented to the court. So on remand, it would be like retrying the whole suppression issue, and that is not an appropriate remedy for this. If there are issues with the representation that defendant received, then obviously 35C would be the proper mechanism to resolve those issues. But when you don't have factual determinations made because the issues were not raised, I don't think the remand would be the appropriate.
And perhaps I've not entirely clear what opposing counsel considered the scope of that supplemental suppression hearing to encompass, but I inferred from that there would be additional taking of testimony, perhaps, not simply limited to the trial court's review of the existing record.
I can't think of any case that provides for that remedy, that because suppression issues were not adequately presented to the court, that the defendant would get a second chance to write a different motion and present different issues. I'm not aware of any case that provides for that kind of remedy.
Okay, and is that because, in your view, as the movant, the defendant was obligated at the outset to identify the specific issues and present them in the first round?
Yes.
Okay.
And that is exactly what Inman says, that it is not only to put the motions, clearly state the motions, but again, Inman goes one step further. If the claim is raised and the court does not address or does not base its ruling on that, if the defendant thinks that that is a valid issue to be addressed, then it has to be raised.
Thank you.
I'm sorry, Mr. Yazzie, I know you had a great finish and we're interrupting your big finish. Could you just respond to Ms. Jeffrey's argument about Seibert? Assuming we got to the merits here, tell me why the evidence does not give you an inference of a deliberate two-step process. She walked through the different factors, same police officer, same questions, et cetera. Could you just respond to that?
My short response to that question is that we don't have the facts to make that determination.
Well, why not? I mean, she told you facts that are in the record. We know it was the same officer. The officer testified it was generally the same questions.
No, well, that's the questionable
Okay.
inference that I would disagree with.
Okay.
Exactly.
So-
And the reason is that, yes, I agree that on the first day of trial, there was a discussion that was actually initiated by the prosecutor, saying that, Judge, I want to make sure that when I'm presenting evidence that my witnesses do not refer to statements that you suppressed. But what are those statements? And in that context, the prosecutor said there's substantial similarity between the statements.
Okay.
That is not adequate to make the inference that it was a deliberate attempt to repeat the same. So one of the factors that cyber requires is the degree of overlap, and we don't have that. And as I suggested again, the detective's cross-examination also allows for an inference that what happened at the police station focused on the gun, the possession of the gun. And of course, the statement was, the incriminating statement was obtained there by saying that, well, it was my cousin's gun, so you will find my fingerprints on that because I moved it. Of course, not to mention that at trial, that defense was abandoned. I mean, those statements were not even, were considered to be a false statement made to the police because the defense was that the passenger actually had placed it. So I would argue that we don't have the facts to even apply. First of all, cyber doesn't apply because there was no two-step, deliberate two-step interrogation. Even if it applied, there was no tainting because the two interrogations were not about the same issues. We don't have that, at least.
Excellent. Thank you.
Unless the court has any questions, we ask the court to affirm the Court of Appeals decision. Thank you very much.
Thank you.
Opposing counsel just said that he could not think of a case where this court remanded for a supplemental suppression hearing after the trial court made insufficient findings under the controlling legal analysis. I know of a case. It's called People versus Magdalenas Aragon, and it was cited to in my opening brief. That was from this court in 1997. In that case, this court compared the findings and conclusions of the trial court to the appropriate legal standard and concluded that the trial court made insufficient findings to permit us to decide whether the consent was voluntary on appellate review. And here's what the court said. The prosecution argues that the trial court's findings are sufficient to permit us to hold that Magdalenas Aragon voluntarily consented to the searches. We conclude that these findings are inadequate to allow us to decide the issue on appellate review. Then the court discusses the voluntariness standard that was incorrectly applied in the first suppression hearing, and then says, in addition, the trial court made no finding as to whether Magdalenas Aragon was in custody at the time the police sought consent, and points out other deficiencies in the trial court finding, and then finally says, because the trial court failed to make findings to resolve disputed testimony in the record regarding the circumstances surrounding the consent to search, our appellate function is hindered. This case must therefore be remanded to the trial court to allow that court to reconsider the voluntariness of the consent under the correct legal standard.
Counsel, if I could just jump in. So making additional findings on the basis of an existing record is distinct from reopening testimony, right? I mean, what, in terms of the supplemental suppression hearing that you're contemplating, what would be the scope of that?
I think that hearing would have to open up to additional testimony if the record evidence is insufficient for the court to make the relevant findings of historical fact under the controlling legal analysis.
And Magdalenas Aragon did not go that far, did it?
Frankly, I can't remember if it did reopen for new testimony or not. I just know that it remanded for another hearing.
you.
Could I ask you, was that an interlocutory appeal before trial?
I believe so, but I think you would know better since you were the prosecutor in that case, Chief Justice.
Do you think that makes a difference if it was an interlocutory?
I thought you might be familiar with the case, that's all. I'd like to also comment in my remaining minute and a half that the state cites Rediger in its answer brief on page 14 for the proposition that an intentional relinquishment of a known right may be implied rather than express if it demonstrates an intent to relinquish the known right. But the state points to no evidence, express or implied, that the defendant considered arguing for a remedy under Seibert, Elstad, or Breidenbach, and then, as a matter of strategy, changed course and decided not to do so. If the failure to preserve a specific argument under a more general claim is due to neglect and not intent, then no waiver has occurred. As Justice Gabriel is pointing out, in People v. Curtis out of this court, and in Johnson v. Zerps out of the United States Supreme Court, appellate courts indulge every reasonable presumption against the waiver of constitutional rights. And as was the case in Rediger, as is the case here, the deficiencies here prove accidental, negligent, or inadvertent failure to a certain right, and not an intentional relinquishment of a known right. I think I only have 10 seconds left, so thank you so much for your time this morning.
Thank you. We appreciate the arguments of both counsel. Case will stand submitted, and we will be in recess till 10:15. Thank you. Please be seated. Next case on our docket this morning is captioned Cardman v. People. We've set this one for an hour. You all have been here before. Ms. Bryan, you want to get started?
Good morning, Your Honors. My name is Catherine Bryan. I'm here on behalf of Mr. Cardman. Mr. Cardman is not present here today because he is currently incarcerated in the Department of Corrections, where he has been held since 2013 based on his conviction in this case. Before I get started, I want to notify this court that I am currently suffering from eye disease known as Graves' ophthalmology or thyroid eye disease. And the reason I'm pointing this out is because it's difficult for me to maintain eye contact sometimes, and one of my eyes kind of flutters. So I might close my eyes in order to concentrate, and I just didn't want anyone to think I'm intentionally being disrespectful or giving anybody mean eyes or any kind of a bad look. It's not intentional.
We call that the stink eye.
Okay.
That's the technical term.
And I also want to point out that there is a typographical error in my briefs regarding a case that this court decided in 1970, which is Velarde versus People. I just noticed last night in the case site, I put 1979, but that case was decided by this court in 1970, and it was also incorrect in my table of contents. So I do apologize to the court and opposing counsel for that error. I would have filed a notice of errata, but I didn't realize it until last night. I'd like to reserve, if possible, 10 minutes for rebuttal, and with that, I will begin. The issue that this court has taken cert on is whether the district court violated Mr. Cardman's constitutional right to due process and reversibly erred by admitting statements Mr. Cardman made to Detective Patton during a custodial interrogation without first determining whether the statements were voluntary and whether Mr. Cardman was entitled to specific performance of direct or implied promises. I'm going to briefly go through the facts which are in my brief to sort of set the stage for what this case is all about. A.W., the alleged victim in this case, lived with Mr. Cardman and her mother at the time of the alleged incident, and they subsequently moved out, A.W. and her mother, when her mother married someone else. For years after this, A.W.'s mother questioned her repeatedly whether she had been sexually assaulted or touched inappropriately by anyone, including Mr. Cardman. A.W.'s mother is a SANE nurse, was a former SANE nurse, sexual assault nurse examiner, as well as an emergency room nurse, and so she questioned her repeatedly about it. A.W. repeatedly denied having ever been sexually assaulted by anyone, and in particular, adamantly denied being sexually assaulted by Mr. Cardman. Years later, A.W. first makes allegations against Mr. Cardman to her new stepfather, who is a former sheriff's officer. And in addition to alleging sexual assault or inappropriate touching, there's a lot of inconsistent statements with that regarding the extent of the touching and what type of touching it was. But in addition to these things, A.W. alleged that Mr. Cardman hit her in the head with a gun, boiled her hands in boiling water, carved the word slut into her legs so that it was so serious of an injury that she was bleeding, her dogs were covered in blood, she was passed out, there's blood all over the bathroom, the towels, and numerous other serious injuries, pouring chemical solutions on cuts, and drugging her, and again, boiling her skin. Her mother, a nurse, never witnessed any of these injuries at all, or blood in the house, or blood on the dogs, or anything corroborating any of the allegations. They are completely uncorroborated. So, as is A.W.'s allegations, which leads the police, in particular Detective Patton, to want a confession in this case. Without it, it is my professional opinion, the case is extremely weak. So, Detective Patton arrests Mr. Cardman on June 6, 2012, at the police station, attempts to interrogate him, where Mr. Cardman invokes his right to counsel and his right to remain silent. Detective Patton, he is then taken to jail. Detective Patton then contacts Mr. Cardman in jail on June 8th. There was a different issue that I'm not going to go into because this court did not accept certiorari on that issue regarding the reinitiation from the invocation of the right to counsel and then the reinitiation on June 8th, which was found to be a valid initiation via third-party initiation through his wife. I don't agree with that ruling, but it's not here. So I will then tend to what we are here is the interrogation that takes place on June 8th. I'm going to go so far as to call this a jaw-dropping unconstitutional interrogation. It is approximately an hour long, and so when I refer to it, I'm going to hit some highlights on it. I cannot possibly read the entire interrogation because it's too long. But when the tape is before this court of this interrogation, and if you haven't, I urge you to listen to it. When I put this tape into my computer, I was really reeling from shock. Jaw-dropping, it is that bad. I think it is blatantly, obviously, glaringly, outrageously unconstitutional interrogation, in which for 54 minutes, Detective Patton, well, first of all, he begins by saying that, contrary to Edwards versus Arizona, that it is his policy, after someone invokes their right to counsel, to wait 24 hours before returning and giving him a chance to say, hey. He then proceeds to tell Mr. Cardman over and over and over again that this case would go away, that part is a quote, if Mr. Cardman would confess and meet AW halfway, admit to some of the allegations. Then he said things like AW just wanted an apology. If Mr. Cardman could give an apology, the officer himself would also be fine with that. He said he was getting off work at 3:30. It was really up to Mr. Cardman whether or not the detective filed the case or put it in a drawer and went home. He said it would be better to take a therapeutic approach. He said DHS wouldn't even care about these allegations if Mr. Cardman confessed to less than 5. While Mr. Cardman was repeatedly denying this, he was saying things like, oh, I can go home tomorrow. The cop is, Detective Patton is saying, yes, let's do it. This can go away. It's up to you.
Counsel, can I interrupt you? I'm so sorry.
Sorry.
Given how outrageous this approach seems to have been, why was no argument of involuntariness made as an argument for suppression?
Well, I'm also shocked by that part as well. So I am shocked that it wasn't included in the defense motion to suppress. So there was a motion to suppress. They didn't want the statement coming into evidence, but they did not raise this legal ground. And I know in Ms. Jeffrey's argument earlier, there was some comment that the public defenders have a stock motion that includes all grounds. Unfortunately for Mr. Cardman, that motion was not filed in this case. There was no boilerplate motion, and it wasn't raised. I am absolutely not contending that it was raised, and for that matter, I don't think the district court would have been on notice of it from the suppression hearing because neither side introduced the taped interrogation at that hearing either. At the end of it, they sort of asked the court thought it wanted it or something to that effect, but neither side moved to admit
And
it.
so I'm going to ask the same question I asked in the earlier argument. I take it that the people, and I think that the Court of Appeals here and the Court of Appeals in many other cases appears to have adopted a rule that there is no plain error review of errors for arguments not raised at a suppression hearing. What's wrong with that rule?
Well, this is different than that, and I think any case cited in the briefs or earlier in a different case relying on Fourth Amendment cases is distinguishable from this case. I am relying on this court's opinion in People v. Whitman, which was decided in 1969, and this is specific to voluntariness claims. It does not have anything to do with search and seizure or Fourth Amendment claims. And this court specifically held in that case that the trial judge is required to conduct a hearing when it becomes evident to that court that voluntariness is an issue. And this is a quote, specifically stated, it is not necessary that there be an express objection by the defendant to the admission of the confession by a motion to suppress or by contemporaneous objection. Rather, an awareness on the part of the trial judge that the defendant is questioning the circumstances under which the statements were obtained is sufficient. This has never been overruled, and this is placing an additional burden on a trial court, in particular in relation to involuntary statements, to take action when it is evident, by which I say glaring, obvious, apparent, and I will point out, I don't think that's ever going to create any floodgates for this court. I have been practicing since 1989. I've handled probably 400 appeals, possibly more, and I have raised what I will call a Whitman and Velarde claim one other time.
This actually brings, were you going to answer?
No, go ahead.
You know, I think most trial judges who've been practicing during the period of time that we've both been practicing, it's roughly the same, would say, Whitman, Velarde, I don't even know about those cases. I didn't realize that I had this independent obligation. And maybe that's in part because 41G arguably abrogates those older cases. And I know you've taken a position that that's not the case. Can you articulate that again now? Why doesn't 41G change the landscape with respect to those older cases?
Well, for one thing, you've never said it does. But that aside, in the
I guess the question becomes whether we should hear.
I know, and I'm hoping that you will not, find that today. But when 41G was passed, it does say that I think the word is shall be raised prior to trial.
No, it says may, and that's.
I'm sorry. Okay, good. I have it here. Then it says may, but it also.
First sentence says may, the second sentence says shall.
Okay, and it doesn't say waiver. So in my brief, I compared it to two different rules which do say waiver. And the rules of criminal procedure that said failure to do certain things would constitute an actual waiver. The word waiver is not in Crim P41, but even if it were, and even if Whitman and Velarde, this court decided to not follow those, there is still plain error, and plain error still exists. And in a case such as this one, where I believe it is a blatantly invalid conviction based on a glaring involuntary confession that is wholly unreliable, I would ask that this court review this case and remand it for a hearing due to the, I'm going to keep saying, the severity of how illegal I believe that this interrogation is.
So that's an interesting point. You're suggesting that we should remand it and not just decide on the existing record that...
That is the remedy in Whitman, Velarde, Poe. The other cases that I cite, Poe is a D.C. Circuit case that used similar language to this court in Whitman and Velarde, but the language in that case is when there is alerting circumstances, the trial court has to take action and determine whether a statement is voluntary. And again, I haven't said yet, I want to make very clear, I am not suggesting that the court has to stop and determine whether a statement's voluntary anytime it comes in. I'm not at all suggesting that. I'm saying when it is, whether our language or this court's language evident to the trial court voluntariness is an issue, or in the federal courts, the words is alerting circumstances regarding the voluntariness of the statement. And these cases that I am relying on, which I don't believe were cited at all in the Phillips case, but what I am relying on have specifically to do with voluntariness.
I thought it was curious that the Court of Appeals opinion didn't feature Whitman and Velarde at all. Did you raise it below?
Yes, yes, Your Honor, I did raise Whitman and Velarde, and it wasn't addressed. In the first Court of Appeals opinion...
Berger didn't even address it.
No, they weren't mentioned.
Yeah.
Well, Berger did in the first
By
opinion.
Berger, I mean Judge
Berger did
Berger.
in the first opinion. In the dissenting first opinion by the Court of Appeals, Berger did mention Whitman. That's my memory. In the second opinion, for some reason, it's not there. This is my memory. I'm pretty sure it was in the first dissenting opinion. Not that it was particularly, necessarily that is solely what he relied upon, but in the other opinions, the cases aren't there. And in fact, the court says I didn't cite any cases, but they are in my briefs filed in the Colorado Court of Appeals. They were ignored by that court. So,
And I wondered if implicit in that isn't their realization that maybe 41G wins the day, but I don't know.
I'm not sure, Your Honor, and I can say the best I could come up with, and I don't know if this is accurate, but there was a little bit of a change in one sentence from the first opinion to the second opinion, saying that I think the first one said I didn't cite any authority, and then the second time it said I didn't cite any authority for the position when the defense had raised a different motion to suppress but didn't raise voluntariness. I see no difference between not raising it at all or raising one thing but missing this ground. So I can't speak for the Court of Appeals, obviously, but they didn't mention the cases. And it may well also be because of Wainwright versus Skice came out after this court's opinions in both Whitman and Velarde, but before the Federal Circuit case Poe, which also in my brief lists a lot of other cases that apply this standard of when the circumstances are alerting, the trial court has to take action. It is my position that Wainwright versus Skice doesn't address the issue at all and is really not particularly helpful, because in Wainwright, the defendant, it wasn't evident. The defendant never even claimed the statement itself was involuntary. If you actually read Wainwright was about whether the Miranda advisement was sufficient. But at that time, and the Attorney General goes through some of this in his brief, there were some people in federal court who never in any way in state court suggested that a statement was involuntary. But then after Jackson v. Deno went into the federal courts, trying to secure a hearing via habeas corpus for the position that Jackson Deno demanded a hearing anytime a statement came in. That is not, my position is not that the court must hold a hearing anytime a statement comes in. My position is the court must do something when it is evident that voluntariness is an issue. So first, Wainwright actually was about whether he states, and he didn't raise it on appeal either, which is important. So Wainwright never raised anything in the state trial court, never raised anything in the state appellate court. And this is important because for whatever reason, but federal courts in many of these cases talk about the defendant didn't raise it on appeal in state court either. And I am aware of that, so I raised it. I'm raising it, and I'm raising it under Whitman and Velarde. But
Could I ask a question about Wainwright v. Sykes? And they're just slightly different, but since you're talking more about Wainwright and with regard to what happened there, do you think it's significant for what we decided prior to that time that we were operating under a federal habeas corpus rule of deliberate bypass, which was changed in Wainwright v. Sykes to the cause of prejudice type of standard? Does that have anything to do with our pre-Wainwright cases?
I'm going to say I'm not an expert on federal habeas review, being a state court public defender, but I'm going to say no for the rationale in Poe and the cases post-Wainwright, stating that it is axiomatic a conviction based on an involuntary conviction is invalid. And as long as a defendant, such as Mr. Cardman, continues to be incarcerated on that, justice is not served. It's my position that justice has not been served in this case. And so, federal review aside, it violates both the United States and Colorado constitutions for a conviction to be based on an invalid conviction, and that has never changed. Not changed post-Wainwright at all. It is axiomatic. An involuntary confession is not admissible in a court of law, period. So then the question becomes, what type of relief is there? I think is what you're asking in terms of, and federal review, does that change the dynamics of this court in Whitman? I don't think so. I don't think the court in Whitman or Velarde was necessarily focusing on what type of review would be occurring in federal court, because the court was taking action at that time, and that action was for remand. So these cases on this, when it became evident that voluntariness was an issue, the remedy in all of the cases that I am aware of was remand, which is why I sought remand for resolution of that issue.
And in terms of sort of how we categorize these things, so do I understand your argument to be even without a motion to suppress and even without a contemporaneous objection, that it could always be determined later based on, or the judge has an obligation to take outside evidence to determine whether this is voluntary, and then it would amount to plain error if it's involuntary? Is that sort of the sequence of?
It is my position in the rare and unusual circumstances where it is evident to the trial court that voluntariness is an issue, and I do not believe that happens often. So it's kind of its own rarity, like plain error has its own, it's rare and it has to be obvious, and this has a sort of, Whitman and Velarde uses a different language of alerting or evident, but evident means obvious. So they're quite similar, I suppose. I think the court now, post-Rediger, has to do one of two things. One, determine if it's voluntary, or two, draw counsel's attention to the applicable law and say, whoa, sounds like you're saying that this confession was coerced, which trial counsel absolutely did say that throughout the trial. And then the court would have to say, are you purposefully waiving any determination by this court that the statement is voluntary?
And when you say evident, then, so I guess since we're not talking about any outside proceeding like a suppression hearing, you mean if evidence comes in at trial from which the judge should realize that any statement or confession was involuntary, then he has an obligation to go and explore that at that point?
Yes, I believe that is correct. That is my position.
So when you say, I'm sorry, good morning. When you say evident, and you've said this a couple of times or a few times, you said that the issue of voluntariness has to be evident. I take that to mean that it has to be clear to the trial court judge that there is a dispute or that the defense is questioning the voluntariness of the statement. I see that as different as something being obvious, like maybe this is obviously involuntary. Are you saying that the obvious part is relevant at all in this procedure that you're suggesting, or are you saying that it's just a matter of whether it's evident that defense counsel is questioning the voluntariness of the statement?
I'm trying to be clear, Your Honor, I guess I'm trying to decide what is the difference between the two. I can tell you.
I'm talking about the difference between, on the one hand, having it be clear that defense counsel, as happened in this case, is cross-examining witnesses about the voluntariness of the statement, and on the other, whether the judge is alerted to the fact that, we have an issue here. This looks like it's involuntary. Those are two different things. One goes to the merits of it. The other one goes to whether counsel is challenging it, say, at trial.
The cases have decided different ways. Some of it, the state, in the federal cases that are cited in my brief, sometimes the state, by virtue of introducing the statement itself, sometimes that statement is recorded, other times it's via an officer. That has triggered the court's duty in some of these federal cases alone, pre-cross-examination, by them introducing a statement. I'm going to say that reeks of involuntariness as opposed to just here is the statement. Examples of this are when a defendant has claimed that he was coerced. Some of the courts did it when a defendant was obviously intoxicated. Some of them came up when there was a shooting. I think that was actually Whitman. It was either Whitman or Velarde. When there was actually a robbery, there was a chase, there was an accident, the defendant was in the hospital. He was drugged in the hospital for surgery. So it's coming up in times where both there's been medical coercion, or things that came up that these cases have said that was enough to trigger the court's duty. Again, in Colorado, I think the court's already found it twice, Whitman and Velarde, because in the other cases they have mentioned Whitman and Velarde, but they've said that the circumstances before the court were not sufficient to trigger the court's duty to conduct that inquiry, which is why, in a way, in my brief, I start with it. I think it is de novo review, meaning this court reviews de novo, fresh eyes. Is what happened sufficient to have triggered the court to know that voluntariness of that confession was an issue or suspect or alerting circumstances, or it was possibly invalid?
So I'm confused by the framework here. I'm hearing two different things, and
Sorry.
On the one, no, that may be me. On the one hand, it sounds like the court's duty. I'm not sure if you're arguing because the court has a duty, the issue is preserved, or the court's duty gets you around waiver, and then that brings us into the realm of plain error, which is a separate question.
It is. It's very interesting.
Is it the latter, or which one are we talking about?
It's interesting because these cases aren't set up for waiver because they put the duty on the trial court to look into it.
So what does that get you? Does that get you preservation? So here, we don't even have an issue of just... Let me finish my question. You don't have an issue, it seems to me, of just putting on... All they did is put on the evidence. The defense lawyer actually argued involuntariness, so it's directly put in front of everybody there. Does that get you preservation, or is it just avoid you a waiver?
Could I say it gets me review by this court? Whether I call it preservation or I call it lack of waiver, I'm going to say it gets me review by this court.
Then the question is which standard, right? If it's preserved, then we're not on plain error. If it's waived, if it's forfeited, then we are on plain error. So I understand you get review. So which one is it?
Whitman and Velarde set up its own standard. Right now, I relied on them in the Court of Appeals. Right now, they stand. Right now, I think they were existing at the time of the trial court, so the court should have been aware of them, I'm going to say. So for my purposes, that is what I relied upon. I am asking this court not to overrule them, but to maintain those cases for the rare cases where this arises. But even if the court, so I'm going to say under those cases, that was the trial court's duty to do, notwithstanding lack of objection. Preservation is kind of an odd situation there, but that was the court's duty. And I guess I would say it's, for example, it's the court's duty to properly instruct the jury on law. Let's say a judge said, well, I'm tired, it's late, I'm not going to give any instructions today. I just don't want to do it, I'm not going to do it. And defense counsel didn't object. I think that's going to be reviewable because that is the court's duty. And you might even have problems even if the defendant said, great, I don't want any instructions. I mean, there's some things that are just that bad.
Let me ask you one more question because I know you want to save your time. So let's say hypothetically that we would say you review this for plain error. You're suggesting a remand is required. What does the remand hearing look like? What else What else does anybody need to know? It seems to me the remand would just put the Court of Appeals in the same position we are to decide whether on these facts we have plain error. What is the remand hearing for?
Most of the cases state that they're giving it as a remand to give the state an opportunity to say if they have anything else to present on that. This particular case was audio taped. The interrogation was audio taped, so you know it. Sometimes they aren't, and so it is remand basically to give the state to put on whatever evidence it might wish to try to dispel the involuntariness of that statement, I suppose. Mr. Cardman could also testify. And with that, I'm going to reserve my time for rebuttal. Thank you.
Good morning, may it please the court. My name is Gabriel Olivares, attorney registration number 45336, and I represent the people in this matter. A defendant who fails to adhere to the procedural requirements of Rules 41G and 41E has waived his claim for review on direct appeal. Rules 41.
I'm going to jump in right away, Mr. Olivares. What's the basis for that?
The basis for waiver is if you read Rule 41G, and especially as it has been interpreted in cases like Gauker, Barella, and Tyler, there are procedural requirements that a defendant must...
41G says that if defendant agreed by the involuntary confession or admission may make a motion under this rule, blah, blah, blah. The motion shall be made and heard. Why doesn't that say you may make the motion, and if you do, it shall be heard prior to trial?
It absolutely does say you may make the motion, and then you don't have to make the
But
motion.
you said you construe that as it's required or it's waived. You are out of court. What is the basis for saying you are out of court if you don't raise it at a suppression hearing?
Well, how I interpret the may in 41G is that you do not have to challenge an involuntary statement. You have the option to let it be admitted. There are strategic reasons to allow an involuntary statement to be admitted. Perhaps you don't think, perhaps it's exculpatory. Perhaps, as Judge Berger stated in his concurrence, this is the only opportunity short of the defendant testifying to get his words in front of the jury.
Why can't you do it at trial, just like a motion, an objection to evidence?
Because
why is it waived?
And that's how it used to be. Pre-1970, in the time of Whitman and Velarde, I will concede that we were under a contemporaneous objection rule as it applied to statements. Now, in 1961, this court, or the Rule 41D was adopted for Fourth Amendment violations, but 41G wasn't adopted until after Whitman and Velarde. It signaled a departure from the contemporaneous objection rule. And I think if you look at the historical context of it, in 1968, the federal courts developed interlocutory appeal for the first time. We didn't have interlocutory appeal before 1970. So why would, there are very good reasons, and there's many opinions from the 60s that say it is best practice to file a pretrial motion. But I really think with the advent of the interlocutory appeal, pretrial motions to suppress became necessary. Because as the 10th Circuit said in Mauro, if you allow a motion to suppress be brought mid-trial, interlocutory appeal is rendered meaningless. And interlocutory appeal is not a mere formality. It's not something that we can just do away with. And I think allowing mid-trial motions to suppress would do that.
But your argument, it strikes me, as focused very much on, the people's position, and I understand it. It's, you make a compelling argument here. But, we've got to focus on justice here, too. So, Judge Berger, obviously, in his dissent, was fairly passionate, and he started by saying words like, short of torture, he's never seen a confession or a police conduct more likely to get an invalid confession. Let's take a case that's not this one. Let's say we had a confession after a suspect was beaten up in an interrogation, and for whatever reason, the defendant didn't make a motion to suppress. Is it your position that the trial court it's powerless, it's waived if it comes up a confession was beaten out of the defendant at trial?
Under Rule 41G, a trial court would abuse its discretion if it heard an untimely motion to suppress.
How is that justice? I mean, we're talking, my hypothetical, we're talking the defendant, a confession was beaten out of him, and you're saying that we can go ahead with that trial?
I think there's two.
Obviously, I don't mean to be passionate on you, but it's a concern.
No, and I think there's two considerations: the constitutional consideration and the rule consideration. Wainwright v. Sykes addressed the constitutional consideration. It said, addressing a very similar rule under Florida's rules, that a defendant must bring a pretrial motion to suppress. And if that defendant doesn't bring a pretrial motion to suppress, it barred direct review and it barred habeas review. And under Wainwright v. Sykes and Henry v. Mississippi, the U.S. Supreme Court held that procedural defaults for the assertion of constitutional rights do not offend the Constitution as long as there's legitimate state interests. And there's many legitimate state interests. I mentioned interlocutory appeal, but rules 41G and 41E allow for the timely pretrial resolution of these matters.
Could I interrupt you right there, just to make sure we're on the same page with regard to the rule? You state that very emphatically and definitively, but the rule even permits the court in its discretion to entertain a motion at trial, doesn't it?
Yes, and so the question would be what are the boundaries of the court's discretion? What can the court consider? And if you look at Barella and Tyler, they outline what the court can consider. And the court should, in determining whether or not to exercise its discretion, the court must consider the circumstances for the late motion. And under certain circumstances, such as court scheduling or witness availability, the court may find it in the interest of the defendant to hear a late motion, not necessarily an untimely motion, but a late motion. But those considerations must be weighed against the prejudice of the prosecution, and only where the defendant or the considerations weigh in favor of the defendant or are closely balanced can the trial court exercise its discretion and hear a late motion to suppress. Otherwise, there are real procedural inefficiencies that are created by allowing, just opening the doors to late motions to suppress.
Yeah, I can appreciate that, and we clearly fall into the category and have since whenever, early 70s, that, a pretrial motion rather than simply a contemporaneous objection. I thought I heard you saying that it would be untimely and you had simply waived if you failed to raise a pretrial motion, but that would be a little overly broad, wouldn't it?
If you fail to bring a pretrial motion and you bring it, essentially for the first time on appeal, it's my contention that's an untimely.
What about if you bring it at trial?
If this motion had been brought during the trial with no other explanation, because we have no explanation on the record, but based on, Your Honor, after the audio tape is played, I'd like to make a motion to suppress. I don't have any reason. I think the trial court would abuse its discretion to hear that motion.
Even in the torture hypothetical I gave you?
Under Rule 41G, yes.
But so you talked about prejudice to the prosecution, which again, I understand your argument. Doesn't the prosecution have an interest in securing a verdict based on fair evidence? Why wouldn't you want it if you're the prosecutor in that trial to say, well, let's figure out if this was an involuntary confession or not?
I would question what the prosecution, I know the counter is going to be the prosecution has a duty to ensure a fair verdict, but I would question really what the prosecution did wrong in this case. It provided discovery of the statements. And the statements, I can certainly appreciate Ms. Bryan's take on the statements, but I think on their face, this isn't a police officer beating someone in the corner of a room.
But it is, and I want to be clear, Mr. Oliveris, I did not in 1 second intend to disparage the prosecutor here. I'm not saying they did anything wrong. The question is whether the defendant gets a hearing here. And so I want to be really clear. I wasn't intending to suggest that. So I interrupted you. I apologize.
No. So I think the prosecution did everything it should do under the rules. It provided the statements to them, and the defense counsel chose not to. And what we can infer by his inaction that he made an intentional choice not to file a motion to suppress. He did file a motion to suppress on other grounds, and I don't necessarily agree with the majority's opinion below that this might be a different case had he not filed a motion to suppress. I think I agree with Ms. Bryan. It is the same if you file a motion to suppress on different grounds or no motion to suppress at all. Where I disagree is the effect of that, and that is a waiver.
Oh, go ahead, I'm sorry.
No, I'm done. Thank you.
Can you highlight for me why you think this was an intentional choice? I mean, it's a confession.
Well, I think there is evidence in the record that it was an intentional choice. But absent that, I don't think we actually need affirmative evidence. If you look at Hinojosa Mendoza, and this 16-3309, by the way, also says, uses the word may. It doesn't say you shall request.
If we're debating whether it's a waiver or forfeiture, help me understand how this is waiver.
Well, again, under Hinojosa Mendoza, where you have a procedural rule that puts a requirement.
You're going back to the 41.
41G,
Okay.
exactly. If we didn't have 41G and we were under Whitman and Velarde, I do believe there would be a question, especially after Rediger, of whether this was waiver or forfeiture. But because 41G created an affirmative duty on defense counsel to make it a timely assertion of his rights, the defendant's constitutional rights, his failure to do so can be inferred as an intentional relinquishment of a known right.
What should we, I'm sorry,
No,
go ahead.
I'm shifting gears a little bit, but do you want to
I
follow
was going
up?
to just ask a quick follow-up on that point, and this discussion brings to mind the difference between Rule 41 and Rule 12. Remind me what your argument is about Rule 12 explicitly referencing waiver, whereas 41G does not.
Two things on that. First, Rule 13.3.309 also does not say waiver, yet this court in Hinojosa Mendoza and Cropper still found waiver. Second, if it's forfeiture, if you look at the intent of 41G, I think waiver is the only conclusion you can come to. Remember, waiver creates Rule 41G creates a waiver by inaction because the failure to bring a timely motion before the trial court precludes the defendant from raising the late claim to the trial court with limited exceptions. It would make little sense to not allow the untimely suppression claim to be brought in front of the trial court, but allow it to be brought in the appellate court under plain error review. And finding a plain error would just be telling the trial court, you should have heard the suppression motion in the first place. So what 41G does is act as a cutoff, except in limited circumstances, and I will agree with that. There are circumstances where 41G is not applicable, where the grounds weren't evident, or the opportunity didn't exist before, or at the discretion of the trial court under those special circumstances. But it acts as a cutoff to the defendant, and if he doesn't raise his claim in a timely manner, he has waived it. Or we can call it a procedural default. I don't think we're tied to the word waived. What it is a procedural default, where if you don't raise it in a timely manner, then you can't assert it at all, at least on direct review.
My follow-up was going to be with regard to plain error. If we disagree with you and we do get to forfeiture, how is this not plain error?
So I think the question first the court would have to ask is, what does plain error review mean in this case? And I don't think the question is, should the trial court have sua sponte exercise its discretion to entertain the untimely and unraised suppression claim? I think the question is, could the trial court have sua sponte exercised its discretion to entertain the untimely and unraised suppression claim? And like I said before, there's only certain circumstances where a trial court can exercise its discretion. And my reading of Barella and Tyler is that the trial court cannot consider the merits of the suppression claim. It would make little sense for the trial court to have to consider the merits of the suppression claim to determine whether it should hold a hearing to determine the merits of the suppression claim.
So you're saying the court shouldn't, but I too would like an answer to Justice Boatwright's question. Say we disagree that the court has to do it. I mean, it would seem to me the plain error review, was there error? Was it obvious? Did it undermine our confidence in the verdict? The question is whether the admission of the confession did all that, I think, but maybe you have a different view.
No, I think actually I do have a different view. I think the appropriate review, if we are, and I'm not conceding that we would review under plain error, is to look at the circumstances. And there are certain circumstances where that come up during trial where I would agree that if this is allowable under plain error, that a trial court may be alerted. And it's the circumstances in which the statement is admitted. So under Jensen, which I filed a supplemental authority on, the court, there was no indication prior to trial that the prosecution was going to admit the defendant's statements. And it wasn't until the defense counsel opened the door to the statements themselves that the prosecution then brought them in. Under that situation, the failure to file a motion to suppress is arguably excusable because, you can see circumstances, and I'm sure they happen all the time, where there's a stipulation between the prosecutor and the defendant that these statements won't come in. That why waste our suppression hearing if we're not going to waste our time with a suppression hearing if we're not going to bring them in? Or even in United States v. Poe, from the D.C. Circuit, it's not just the circumstances that the statements were made, but the D.C. Circuit also pointed to the very unusual circumstances that the evidence was brought out at trial. Defense counsel, on the record, had no idea that these statements had been made.
Let me switch the question then. I want to know, how are these statements not involuntary?
So the statements themselves, if this court were to review this,
Right.
Well, I think the first question also would be, what standard are we looking at? But as this court said in People v. McIntyre in 2014, unanimously reversing the trial court's order to suppress, you can't just look at implicit promises. It is a totality of the circumstances analysis. And so there's many circumstances that suggest the statements were voluntary. The defendant was re-Mirandized during the second interrogation. 2 days passed between the original invocation and when the defendant resumed when the interview.
On the promises. If you just admit to a couple, you can go home and I'll put this in the drawer and we're done. He's in custody. Help me. That's as specific as I can be.
Yeah. One, it's unclear what those promises were asking. We can go home, I can go home. Does it mean charges won't be filed? Does it mean the statements won't be used against you? What is he asking him to admit to? Detective Patton was originally asking him to provide some innocent explanation for these claims. And when the defendant wasn't doing that, he kept pushing him and pushing him. And the defendant continued to resist. That was the argument at trial, right? That, hey, despite the detective's tactics, They weren't working. And look, despite everything the detective did, the defendant continued to deny. So even if there was coercive government conduct, how can we say just that it was obvious that the statements were induced by the coercive government conduct? Plus, there's a lot of information we don't know. And we don't know what we don't know, right? I mean, Detective Patton admitted or testified that the recording was redacted. We don't know what was redacted out of that. We also know from the suppression hearing that there was a video of the interrogation. It wasn't admitted at trial, and it's not on the record here because the video didn't contain audio. But
Who redacted it?
what's that?
Who redacted the?
I assume the prosecution. I mean, they said it was redacted for time purposes, but we don't know what was redacted out. Again, we don't know what we don't know because this wasn't litigated below. And so I think it's easy to just assume that we should just remand this for a suppression hearing. And I mean, defendant admits that you can't just on its face reverse this case under plain error. You have to remand it for a suppression hearing, and that would be only fair. But what does a suppression on remand look like? I mean, what evidence can be considered by the trial court? Can the trial court consider the reasons why defense counsel didn't raise a timely motion? Can he consider whether it was strategic or unintentional? And what's the burden of proof? I mean, normally in a suppression hearing, the burden of proof would be on the prosecution, rightfully so. But we've been operating, as the defendant claims, under the plain error review, where the defendant bears the burden of showing error. So why should it shift back to the prosecution at a suppression hearing on remand, especially after 7 or 8 years have passed, and the prosecution had no idea that they're going to have to litigate this suppression issue again? And what's the standard reversal? Obviously, the standard reversal, it wouldn't just be automatic if either some or all of the statements were suppressed. The trial court would presumably have to make a finding of prejudice. And would that be under constitutional harmless error, where the prosecution bears the burden of showing that there was no prejudice? Or would it be under plain error again, where the defendant bears the burden?
Well, we could evaluate that up
Sir-
front. We could say, determine whether it was voluntary or was involuntary, then there's prejudice and it's reversed.
Yeah.
Or the judgment of conviction is vacated.
But I think if the court starts structuring it in a way under plain error review that might make the most sense, then at the end of the day, all we have is a Strickland hearing.
Well, and I wanted to ask you about that, because there's this, were you finished just about right? Were you going to ask something on this topic first?
Please.
Well, there is this undercurrent of 35C, Strickland's inadequate, right? Judge Berger dropped a footnote to that effect. We heard in the last argument that 35C, post-conviction review, often forces a pro se defendant to litigate these things. Not clear that that would necessarily happen in this case. I'd like to think it wouldn't. But address this implicit argument that 35C is inadequate.
I actually think, right to count, pro se issues aside, I actually think the defendant might fare better if this was inadvertence under a 35C hearing. Remember in Hagos, we said, this court said that the Strickland standard is lower than plain error.
But I can hear sort of in the minds of folks on the other side of the aisle thinking that that's not how it typically plays out, that more typically what we see is Strickland review results in a finding of no prejudice because the choice was deemed to be strategic, even if a lot of people looking at it would question whether it really was, and or there might be an argument that somehow the other evidence was sufficient under that kind of analysis to suffice. And so do you disagree with those concerns?
Yeah, especially if this case is as extreme as it, Ms. Brown paints it out to be. It sounds like what she's advocating is to carve out a very small exception to very extreme cases. And if it's so extreme, then, and if defense counsel, trial counsel's actions were so unreasonable, then why is Strickland insufficient?
Isn't carving out an exception for very extreme cases exactly what plain error review is for?
No, I think what plain error review is for, and as this court said in Hagos and Stewart, is that plain error review is, one of the purposes of plain error review is to temper the contemporaneous objection requirement. As the majority pointed out, plain error review is to really address errors that happen during the heat of trial, where, you know, a testimony could come in and defense counsel might not have heard it, or might have misinterpreted it, or defense counsel didn't have time to research the adequate law. Or in a jury instruction conference, defense counsel didn't realize where the comma was supposed to go in the jury instruction, which changes everything. But defense counsel here, Mr. McGuire here, entered his appearance, I believe, in June of 2012, and the second trial was in November of 2013. So he had a year and a half to prepare for this trial. At 2 trials, he heard the statements twice, and not once did he make an objection, even an untimely motion. And there are reasons to make untimely motions, and I think plain error review would discourage even making untimely motions. Maybe the trial court would exercise its discretion. Maybe the prosecution would agree to the suppression hearing because it knows on its facts it will succeed, and it doesn't want to take its chances on 35C when witnesses might not be available, when memories fade. Or maybe the prosecution will evaluate its case and decide this evidence isn't worth it. My case is strong enough. I have other statements from the defendant. I have other evidence that I can bring in that conclusively prove his guilt, and they forego admitting that evidence. So there are all sorts of reasons why we shouldn't discourage timely motions and untimely motions, neither of which we had here.
No, I guess what's unsettling about the position that you're advocating is it goes back to what Justice Gabriel was talking about earlier, where if something is so egregious that there really was torture, or there was, something that everybody looking at would say this never should have come in at trial, you still seem to be saying in the absence of a proper motion, then that's something that's just going to have to be resolved based on 35C. And at the very least, the net effect of that is that somebody sits in prison until you get to the 35C hearing.
Certainly. And, I mean, at this point, would the 35C hearing be that much later, or would it even be later than if this court remands it for another suppression hearing?
I guess what we're talking about is setting up a regime in which the safety valve would exist earlier, and this could have been remanded from the Court of Appeals, and you'd get it resolved a lot quicker.
Well, I think if the court makes a conclusive ruling, the defendant would probably know that he can't raise this in a time on direct appeal, and then would have a choice whether or not to proceed right to 35C. I mean, it's no different than any other Strickland claim. And I hope, I think this court realizes that I don't approve of, coercive government conduct, or I'm not even asking the court to approve of the conduct that existed here. But 41G was written after Rogers v. Richmond. It was written after Jackson v. Deno. It was written after Whitman. It was written after Velarde. And 41D, remember, existed in 1961, yet we still wrote 41G. And 41G specifically says, a defendant aggrieved by an alleged involuntary confession. It specifically talks about involuntary confessions. It doesn't say kind of involuntary or sort of involuntary. It covers all involuntary confessions. And certainly the writers of this rule realized the implications that it created when they wrote the rule. Briefly, I can just walk through why I also think that the specific performance would fail, and because the defendant didn't adhere to the requirements of 41G. Really, the court has no inherent authority to enforce an unauthorized promise of transactional immunity, and I think that's what would be suggested here is an unauthorized promise of transactional immunity. So the defendant's reliance can only be enforced through use immunity. And use immunity really is the functional equivalent of a suppression ruling where the statements specifically are suppressed. And this court has analyzed suppression or grants of use immunity under 4.1a, presumably because 4.1a is limited to 41E and 41G and then 41.1, that necessarily those statements are suppressed through 41G. And 41G has really been broadened to include not just involuntary statements, but also statements really alleged to have been procured in any unconstitutional matter. And so because the defendant did not comply with 41G, he, as I said, either waived or procedurally defaulted his claim. If this court has no further questions, I'd ask it to affirm the Court of Appeals opinion. Thank you.
You. Brian, you have about 5 minutes.
I want to just clear up some things. In the first Court of Appeals opinion, Justice Gabriel, is on page 66, where Berger in his dissent did reference Whitman, and he also referenced Copenhaver, which came out after 41, long after, and that case cited both Whitman, and I think Velarde, but definitely Whitman.
Brian, can I ask you to address the interlocutory appeal issue that came up after the rule, 41.1? What I'm worried about is if we follow Whitman, it's going to incentivize people not to raise involuntary issues till during trial, and then the people couldn't appeal and jeopardy would have attached.
Okay. I don't think it's going to incentivize that. I don't think there's going to be a floodgate. I have been aware of Whitman and Velarde for decades. I have raised this claim once. People are not raising this often. It has to be evident and obvious. It doesn't come up often, and this court can certainly write an opinion with language stressing how rare a situation it is for a court to intervene when defense counsel has neglected and failed to raise a claim regarding voluntariness. And it doesn't fall only to defense counsel. There are ethical obligations set forth in my brief and ABA standards that prohibit a prosecuting attorney to introduce unreliable evidence. They must take steps to secure the reliability of evidence when there is a question as to that. And I'm going to draw a quote to Poe because I love it, which says, "A trial court is not a passive bystander in the arena of justice, a mere spectator at a sporting event. A trial court has a duty to protect and vindicate a client's constitutional rights." So yes, in most instances, it should definitely be raised prior to trial. It wasn't. Counsel missed it. They were public defenders at the time of my brief. They're judges now. I will now say they were ineffective. That is not the issue on appeal. The issue on appeal is whether the trial court had a duty to do something when this outrageous interrogation got laid before him. Justice Gabriel, blood is not the only hallmark of an unconstitutional inquisition. That is a quote from Jackson v. Deno. This is when you promise someone their liberty, if they confess to less than 5 sexual assaults, that is a binding promise, and even if not, the statement is involuntary.
Let me just jump in. What about the argument that, well, if this is so egregious, then surely this is the poster child for 35C relief under Strickland? Maybe relief doesn't happen very often that way, but in this case, it's more viable, contrary to what Judge Berger said in his footnote.
It is viable for relief. It is also, I would agree what you said previously, a more timelier resolution. Would this law have been, had the Court of Appeals followed Whitman and Velarde, as they have in other cases, both published and unpublished, much speedier resolution. Years ago, Mr. Cardman would have been released. But instead of that, they didn't follow it. I appealed. The court took cert, it was remanded, I lost again, and we're back here. So years have gone by. Mr. Cardman's been incarcerated on a blatantly invalid conviction for over 6 years. So I think that a hearing would be a speedier justice and obviate any further injustice to Mr. Cardman being wrongfully incarcerated on this case. 35Cs take extensive time, and part of that is my concern is not losing. My concern is time, because you have to raise all claims that can be raised, not just one, and that takes a long time to litigate. And this is a relatively easy hearing, and I'm going to end by saying, because I don't know if this court knows, and if you want to disregard it, you may, but it is in court data, which the court can take judicial notice of. Detective Patton has been removed from the force from felonious behavior in another case involving dishonesty, deception, and gross misconduct. He is a bad cop. And unfortunately, so with that, I would say if the court wants to just find this confession involuntary and vacate the conviction, I would gladly and gratefully accept that relief for Mr. Cardman. I don't think in this case the remand's going to inure to the prosecution's benefit, because Detective Patton will be impeached if he attempts to change his story based on his subsequent felony for attempting to influence a public servant. Any questions? Then I will ask that this court reverse the Court of Appeals opinion. Thank you.
Thank you. Appreciate the arguments of both counsel. The case will stand submitted, and the court will be in recess until 1 o'clock.